So without further ado, John Hostettler is going to take us to school about the Constitution and Christ.
Good evening. Before I begin, I just need to make a couple of corrections. Sometimes when you make out a bio for friends to read and to announce, you get the words and lines so close together that sometimes the words kind of blend. I served on the Judiciary Committee my last 6 years of the service in the House of Representatives. And in that capacity, I did serve on the Constitution Committee. I was chairman of the subcommittee on Immigration, Border Security, and Claims for 4 years. It's just because they figured they couldn't make me chairman of the Constitution Subcommittee because it would be too many problems. So, but I did serve in that capacity on that subcommittee on immigration. Also, Susie brought up defunding the federal courts. I didn't get an opportunity to defund the Supreme Court because they did what we wanted them to do. And but we did vote to defund the 11th Circuit Court, 9th Circuit Court, and the Southern District of the state of Indiana. After we did that, the Supreme Court decided for the first time in 25 years that the placement of the Ten Commandments on public property was actually constitutional. Or 3 shots across the bow, and they get it. I want to thank, first of all, Peter and T-Mac for the invitation to be here tonight and share with you. It's a tremendous encouragement for me that you all are so willing to become this involved. In 1962, the United States Supreme Court, in a landmark decision, Engel v. Vitale, referenced a passage in an 1802 letter sent by then-President Thomas Jefferson to a group of Baptists in Danbury, Connecticut. We Baptists are always causing trouble. We apologize for that. The case before the justices involved a prayer that was created by a New York State board and provided to local public schools in that state for voluntary recitation by students. The passage, which Thomas Jefferson plagiarized from the Baptist theologian Roger Williams, alluded to a wall of separation between church and state. In his opinion for the majority, Justice Hugo Black described this particular wall as constitutional. And so for the first time in the history of the Republic, the High Court deemed prayer in public school a practice which predated Roger Williams' grant of the charter of what we know today as Rhode Island to be unlawful. A year after this fabrication of farce produced by the Supreme Court, it did itself one better. In the 1963 decision, School District of Addington Township v. Shem, the court effectively eliminated all Bible-based curricula from America's public schools. The court recounted the expert testimony at the trial court of Dr. Solomon Greitzel, who testified, quote, "If portions of the New Testament were read without explanation, they could be, and had been, psychologically harmful to the child." End quote. The notion that the New Testament was the source of psychological harm to school children was obviously compelling to the justices in 1963. Lawyers familiar with the process of delivering arguments at the Supreme Court would say that the mention of the good doctor's testimony in the court's written opinion is among the mere dicta included in the opinion and not worthy of any considerable attention. It is, however, worthy of our attention tonight. The suggestion that the pronouncements of the New Testament, in contrast to those of the Old Testament in this case, are harmful to children is anathema to every person who has heeded Christ's call to be born again. It was the Apostle Paul who reminded us that it is the gospel found today in what we know, and the court knew in 1963 as the New Testament. It is the power of God unto salvation. How can that which gives eternal life be harmful to the mind of a child? And just as important to our discussion here tonight, what had to be the state of the church in America in 1963 for it to have allowed this suggestion by Dr. Greitzel and its acceptance by the Supreme Court to have gone essentially unchallenged? To be sure, there were likely sermons and radio interviews and letters to the editor and all sorts of chest-pounding that abounded and pronounced condemnation of this opinion. But where did all that pontificating get us? Well, you can look around at America today and you will have the answer to that question. What should have happened in 1963, you might ask? I'll answer that question later in my remarks. Just realize this before we get there. It is never too late to set things right. For now, let's return to Dr. Greitzel's testimony. Recall that in his expert opinion, the reading aloud of the New Testament without explanation had caused psychological harm to school children. This is interesting content and opinion of the Supreme Court, especially in light of what that court said almost 120 years prior in another decision. In 1844, in the majority opinion concerning the case Vidal versus Gerard's executors, the court rejected the pleas of the complainants who wished that a school funded by the estate of the deceased billionaire be free from religious instruction pursuant to the wishes of the deceased. In rejecting not only the desires of the complainants, but also the obvious wishes of the dead benefactor, the High Court said this in its opinion, quote, "Why may not the Bible, and especially the New Testament, without note or comment, be read and taught as a divine revelation in the college, its general precepts expounded, its evidences explained, and its glorious principles of morality inculcated," end quote. The Supreme Court didn't need to bother with so-called expert testimony of anyone to pronounce its belief that the reading of the Bible, especially the New Testament, was desired so that, quote, "its glorious principles of morality could be inculcated," end quote, in the minds of school children. We are left to ask ourselves the question, what changed between 1844 and 1963? Granted, we could spend days discussing the cultural evolution that took place between the time of 17 years before the Civil War to a time 3 years into the Vietnam War. We would no doubt spend much time in trying to evaluate the change in public morality and private adherence to biblical precepts which fashioned the thinking and actions of our elected and appointed federal government leaders. We don't have time for that very important discussion tonight, but I'm sure that Peter is working on that for the second annual TMAC Pastoral Conference. Rather than summarizing that history, I will focus on the change in our Constitution that took place during that time, which the High Court has misapplied to get us where we are today, adrift. Following the Civil War, the Congress passed legislation in 1866, the Freedmen's Bureau Bill, to protect the privileges of former slaves. While the 13th Amendment had granted Congress the authority to legislate the freedom of slaves, it was clear to everyone involved that the freedom bought by the blood of hundreds of thousands of Americans and enshrined in the Constitution as a result of the last full measure of their devotion did not include the privilege to contract, to sue, to give evidence, to take and hold and convey property, as well as to enjoy the benefit of the laws to secure the person and property of former slaves. This deficiency was clear to the Congress in 1866 as a result of previous Supreme Court rulings which found no explicit authority in the Constitution for Congress to legislate against states' rights. Therefore, there was a problem with the 1866 bill. Even with the 13th Amendment, there still existed no constitutional authority for the Congress to pass it. And so, after the fact, the Congress set out to grant itself authority to pass what it already passed. A constitutional example, if you will, of getting the cart before the horse. Their solution for the horse that would ultimately pull the cart that carried the Freedmen's Bureau Bill was what we know today as the 14th Amendment, which, among other things, states, quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, and nor to deny any person within its jurisdiction equal protection of the laws," end quote. While the ratification of this amendment cleared the way for judicial acceptance of the Freedmen's Bureau Bill, it also laid the foundation for a wall of separation that the Supreme Court would ultimately erect. Or so the late Justice Hugo Black would have us believe. In the 1947 case, Adamson v. California, the Supreme Court was confronted by an appellant that claimed the state of California had not afforded him due process in a criminal trial because the appellant felt compelled to give testimony against himself contrary to the Fifth Amendment of the United States Constitution. Justice Black suggested that in his exhaustive study of the record, at the time of the passage of the 14th Amendment, it was the intent of Congress that the 14th Amendment incorporated the Bill of Rights and made the Bill of Rights applicable to the states. Justice Black said, quote, "My study of the historical events that culminated in the 14th Amendment and the expression of those who sponsored, favored, and favored, as well as those who opposed its submission and passage, persuades me that one of the chief objects of the provisions of the amendment's first section separately and as a whole were intended to accomplish was to make the Bill of Rights applicable to the states, end quote. While the majority of the Adamson Court did not agree with Justice Black's view of history, he would get his day. 15 years after Justice Hugo Black published the conclusions he drew from what he called his, quote, study of historical events, end quote, his dissenting opinion, he wrote the majority opinion for a case and stated, quote, the First Amendment was added to the Constitution to stand as a guarantee that the people's religions must not be subjected to the pressures of government for change each time a new political administration is elected to office. Under that amendment's prohibition against governmental establishment of religion, as reinforced by the provisions of the 14th Amendment, government in this country, be it state or federal, is without power to prescribe by law any program of governmentally sponsored religious activity, end quote. For what case did Justice Black deliver this majority opinion which solidified the notion that the 14th Amendment incorporated the First Amendment's prohibition of governmentally sponsored religious activity? It was the 1962 school prayer case, which I began this presentation. So was Justice Black correct in 1947 when he wrote his dissenting opinion? Was he right when he wrote the majority opinion in 1962 concerning school prayer? Was he correct then? And are modern-day justices correct today when they suggest that it was the intent of the Congress in 1866 to incorporate the Bill of Rights into the 14th Amendment and make them automatically applicable against the states? When I say automatically, I mean, did the Congress intend for the federal judiciary, and more specifically the Supreme Court, to be the branch of the federal government to enforce the provisions of the 14th Amendment by means of their opinions? The answer to that question is clearly no. Early in our discussion of the 1866 Congress and the protection of privileges of freed slaves, I quoted to you Section 1 of the 14th Amendment. That amendment actually has 5 sections. If you recall, I mentioned to you that the Congress knew that prior to the 14th Amendment, the Supreme Court ruled that the Congress had no explicit constitutional authority to enforce laws against the states, even when those states arbitrarily withheld the protection of privileges from certain purposes. In order to remove all doubt that Congress would have the explicit constitutional authority to legislate on future matters, Congress began with the 13th Amendment to add language to future amendments that left no question of Congress's legislative authority on all sorts of actions. That language, in one form or another, was the language of Section 5 of the 14th Amendment, which stated, quote, which states, I should say, quote, the Congress shall have the power to enforce by appropriate legislation the provisions of this article, end quote. Returning to my question, did the Congress intend for the federal judiciary, and more specifically, the Supreme Court, to be the branch of the federal government to enforce the provisions of the 14th Amendment by means of their opinions? Once again, the answer is without doubt, no. Regardless of what Justice Black claimed to be the obvious desires of that Congress, they very clearly, emphatically, and explicitly commanded that it would be, quote, the Congress that would have the power to enforce by appropriate legislation the provisions of the 14th Amendment, end quote. It was never to be that the Supreme Court would enforce by their opinions the provisions of the 14th Amendment. In fact, as Professor Charles Fairman pointed out in an article published in the Stanford Law Review in 1949, quote, direct application of the several clauses by the judiciary received no attention, end quote, in the congressional deliberation on the 14th Amendment. So it is the sole prerogative of the Congress, not the courts, to legislate and enforce the 14th Amendment.